Good evening, colleagues, and welcome to the Project Management Guru series delivered by the Project Management Guru. Today, I want to continue my series on construction contract management. I'm looking at various issues that sometimes can turn out to be very difficult for your various construction contracts. So today, I want to talk about the conditions of contract. And I'm talking specifically to contractors, subcontractors, suppliers, and service providers. These conditions of contract, or these terms and conditions of your contract, sometimes contain what we call onerous terms and conditions. And in this presentation, I want to actually explain to you what the onerous terms and conditions are and what your obligations has to be with respect to these onerous terms and conditions in your contract. So at this juncture, I would like to explain to you what an onerous terms and conditions in a contract mean. These are unusual or particular terms and conditions of contract. More or less, they are non-standard terms and conditions of contract, usually embedded in your contract. Most cases, you'll find it in the fine print at the footers of the contract or on the reverse side of quotations on pro formas. And these onerous terms sometimes can be very unfair or ill-considered, and sometimes they are one-sided. They favor only one party in the contract. For instance, you can have onerous terms that are limiting or excluding liability for damages for one party. Or it might be conditions which might cause a significant imbalance in the other party's rights. For example, if you remember the case between Shylock and Antonio, the story told by Shakespeare in The Merchant of Venice, there was an onerous terms and conditions in the contract which says that Shylock would take a pound of flesh from Antonio if Antonio refuses to fulfill his obligations. This is an onerous term and condition in a credit agreement or in a credit contract. So to avoid some of these unfair onerous terms and conditions, certain regulations have been promulgated, like the Consumer Protection Act or the new Consumer Protection Act. These have been promulgated by the Parliament to protect any buyer against some of these unfair or ill-considered onerous terms and conditions in contracts. Okay. So if you find these onerous terms and conditions in a contract, or if they are in a contract, what are the conditions for their enforceability? How can we enforce them in a court of law? First of all, the first condition is these onerous terms and conditions embedded in the contract must comply to the new Consumer Protection Act. It should not violate the rights of the buyer under the new Consumer Protection Act. And then the second condition for these terms to be enforceable, these onerous terms to be enforceable, is that the attention of the buyer had been sufficiently drawn to these onerous terms and conditions at the time of signing the contract. Okay? So without these two conditions in place, it will be very difficult to enforce these onerous terms and conditions. More or less, They will be set aside out of the contract. They will not form part of the contract. So as a contractor, a subcontractor, a supplier, service provider, what are your obligations whenever there are onerous conditions in your contract? Make sure they comply to the Consumer Protection Act to ensure that the buyer's rights are not violated. And then the second obligation is let the buyer beware of these onerous terms and conditions. You must have sufficient proof that his attention was drawn to these onerous terms and conditions. If possible, if you can make him sign off these particular terms or these onerous terms and conditions in the contract, or sometimes you let him initial those terms and conditions as proof that his attention has been sufficiently drawn. It is only when you fulfill these two conditions that these onerous terms and conditions can be upheld. And this issue came up in the case between Interphoto Picture Library Limited versus Stiletto Visual Programs, a 1987 case, in which there were onerous terms and conditions in a contract between these two parties. But unfortunately, one of them failed to draw the attention of the other to these onerous terms and conditions. So when it became an issue and the case was brought to court, the court actually could not uphold these onerous terms and conditions. So contractors, subcontractors, suppliers, service providers who are rendering services or supplying goods and materials to clients, please make sure that if you have onerous terms and conditions in your contract, make sure the buyer or your clients, their attention is sufficiently drawn to these onerous terms and conditions. Let them sign these onerous terms and conditions off to indicate that their attention has been, and make sure these onerous terms and conditions does not violate the new Consumer Protection Act. It is only under these two conditions that whenever these onerous terms are violated, the court can, or you can win under these terms and conditions in the court of law. Otherwise, they will not be considered as part of the contract. Thank you very much for listening. My name is the Project Management Guru. And don't forget to visit me on my Facebook page, #GCCJBCC, or join my Facebook group, Project Management and More, or visit my website, www.zatiprojects.com, or don't also forget to subscribe to this YouTube channel as you watch this video. Once it's completed, please click on the subscribe button and join my YouTube group as I continue to teach you on some of these or discuss with you some of these construction contractual issues. Thank you very much for listening. You can also join my weekend programs. I have one-on-one sessions with anyone who is interested. Just give me a shout or call me or WhatsApp me on 082-727-8736. And I can teach you on one-on-one sessions on some of these construction contract management issues. Thank you very much and have a good evening.